While we wait for Tejas to begin, we are switching gears for a moment. We'll go to Atlanta, Georgia, recapping the latest in the racketeering trial against rapper Jeffery Williams, also known as Young Thug. The rapper, along with 5 co-defendants, charged with a whole mess of gang-related crimes connected to the alleged street gang, YSL, short for Young Slime Life. The state alleges those crimes range from drug distribution, firearm possession, armed robbery, murder. But on the other side, the defense says, no, come on, man, YSL just is a record label, Young Stoner Life, because we got a lot of challenges in life, and these address the themes of those life circumstances. Earlier this month, Kenneth Lil Woody Copeland retook the stand after that 8-week hiatus. Prosecution continued to question Copeland about his alleged involvement in the January 2015 death of YSL gang rival Donovan Thomas, who was killed in a drive-by shooting in Atlanta just outside a barber shop. Now, multiple police interviews were played for the jury. Investigators pressed Copeland for information related to the event. Copeland vehemently denied that YSL was a gang and no involvement with the Thomas death. However, Copeland did admit on the stand that he gave his friend, known as Threat, the rental car used in the Thomas murder, and said the car was originally rented by Young Thug. Copeland is expected to return to the stand on Monday, so we'll have to wait and see what happens next in his testimony. But let's take a look at what happened this week. The jury had a pre-scheduled week off, so Judge Paige Whitaker and the attorneys took some time to handle more redactions to upcoming evidence in the state's case. Toward the end of the week, a lot of that evidence surrounded phone calls between co-defendants and co-conspirators in this case. And they are arguing, of course, that they further this RICO conspiracy. The prosecution is presenting on Thursday night. Things got heated between the prosecutor, Adrian Love, defense attorney Bruce Harvey, with Judge Whitaker needing to step in. So take a look at this situation.
We don't believe that they have met, and by they I mean the opponents of disinformation coming in. They have not met their burden of showing that this statement from Umfunk regarding Nichols telling on himself, and basically Nichols trying to get help for himself, like brother needs to pay for a lawyer. We did it for him. We don't believe.
Hey, no, sir, Mr. Harvey, stop right now. Stop right now. Stop right now. Mr. Harvey, sit down. I am not going to have you interrupt court. I'm objecting. You may object in just a moment. We will get to your objection in a moment. Go ahead.
Thank you, Your Honor. There has been no showing that this information is so substantially more prejudicial than probative that it should permit the exclusion of what we believe is obviously relevant evidence.
Okay, thank you. Mr. Harvey, your objection.
My objection is for lying to the court and making things up to the court and saying speculatively to the court that like he paid for Mr. Nichols' lawyer. You got the evidence of that?
I don't even understand that to be what she said. Okay, well, the record will reflect what she said, but I understood her to be talking about what was being said within the context of this conversation we just listened to.
Your Honor, just,
yes,
sorry. Go ahead, Mr. Harvey.
I missed any reference to it. So Well is the person to whom this allegedly...
I'm going to listen to it again. Offline, not in court.
This is where I'm at with this. Just because the state says something is so doesn't make it so.
I understand.
And the state is saying, oh, well, this was done in furtherance of the conspiracy. This was done in furtherance of the conspiracy. The whole point of the hearsay rules, and I understand that the confrontation clause might not be implicated here, but the hearsay rules, the whole point of the hearsay rules is you get to see who's saying it, know what their basis is, you get to cross-examine them, they come to court, etc. And the problem here is the state is just sitting here saying, oh, well, clearly Mr. Umfunk did this to further the conspiracy. And how do we know? How does she know? Maybe Unfunk, I'm not saying this is the case, but what if Unfunk was involved? Unfunk would have every reason to shift responsibility to other people. What about the next line in the hearsay ladder that we have? We don't know what people's motivations are. And just because the state says, well, their motivation was to do this or do that, she's not inside Unfunk's head. She's not inside Rel's head. So I reject that their argument that they can just label things as hearsay exceptions and it makes it so.
Well, I understand that. I take what everybody says as your argument in support of your position. I don't accept it as fact. It's an argument. I hear the counter argument. Sometimes I hear a lot more counter arguments back and forth after that, and then I make a determination about whether our evidence rules permit this particular evidence. The point of the hearsay rules and all of the evidence rules is so that to the extent the court can help it, only trustworthy information gets before the jury. And that's what we're trying to sort out here. So I understand that the stakes are high. I think that this might be a good time to break for the day. I will re-listen to this.
Okay, so again, I had such high hopes for the new judge and maybe moving this thing along. I know this week was planned to be off for the jury, but what about the time that's being used? Is this being used in the best way possible? Katherine Lizardo still here, Maddie Mangino. So Katherine, just kind of a broader question about the process and the judge, this 1 week off again for the jury, but it seems like we are relitigating so many things that happened before. Why couldn't the judge just say whatever was handled prior to the recusal is going to stick, and we're not going to open up that stuff again?
Well, because the judge was not there when all of that happened, and also because now as a new judge, she has to make her own ruling as to what this should be. Of course, it's interesting because it's not a new trial per se, but these parties are re-raising the issues because they were not happy also with the ruling of the previous judges, especially with Judge Glanville. And the reason why Judge Glanville was actually taken out from this case is because of that ex-parte hearing that we've been hearing about, why that caused this whole trial to be put on hold. So this judge has to walk a fine line as to whether or not she's going to agree with the ruling that Judge Glanville had, or how she's going to handle her courtroom here. But as we were looking at that, I was thinking they need to take a break. And I'm glad the judge said, let's go ahead and take that break, because it's so heated.
It was getting a little testy there. But, you know, Matt, and I don't mean to bag on Judge Whitaker because she's inherited a nightmare, but how do you think she's doing?
Well, I think she's doing the best that she can under the circumstances, but she's really been put in an impossible position. Okay, so number one, she has to preside over this case, and judges don't always agree with one another. She may not agree with some of the rulings or the foundation for those rulings. And now, she'd be second guessing the other judge, as well as trying to create a clean record for this case to go forward. And then also it opens the door up to the litigants who can turn around and say, hey, this is a second bite of the apple. I got a new judge. Maybe I can somehow reconfigure these arguments and get them back in front of this judge, and maybe she'll give me a better ruling. So I just don't understand why this case continues. It's been, so long. You have a second judge. You're rehashing arguments that have already been heard by the court. I really don't see this as an effective way to bring justice to these defendants and frankly to the state in presenting their case.
Yeah, and it's going to continue, and we all believe if there is a conviction, probably going to be tough on appeal to uphold. Anyway, as I continue to argue with myself about this, whether it's right or wrong with what the judge is doing, we know attorneys are going to say, look, I need to make a record. I understand what you're saying. I've got to make a record. stand up like the whack-a-mole and do your thing and make your record for appeal. Okay, so believe it or not, there are other issues in this case that have nothing to do with the actual underlying acts that are alleged against the defendants. We're going to talk about the one against Attorney Steele. Remember that whole contempt? You're going to do 20 days in jail. We're going to talk about that when we come right back.